In this module, we're going to focus on youth crime, young offenders, and most significantly, the youth criminal justice system in Canada. We're going to begin with a broad overview of youth crime and young offenders in Canada, primarily looking at statistical data with respect to these issues. We'll then head into the more theoretical part of the lecture, which looks at the different responses to youth crime in Canada, or any country for that matter. And I've basically categorized the differing responses to youth crime in four areas: prevention, treatment, punitive sanctions, in particular incarceration, and then diversion to alternative justice systems. And we'll spend the remainder of the lecture, much of the lecture, focusing on the Youth Criminal Justice Act in Canada, which is the prevailing piece of legislation with respect to youth crime and youth justice in this country. In other words, all young offenders who come into contact with the youth criminal justice system in Canada do so under the auspices of the Youth Criminal Justice Act. So the provisions of the Criminal Code of Canada generally do not apply to young offenders, and in young offenders we mean between the ages of 12 and 17. So no youth under the age of 12 in Canada can be prosecuted criminally in this country or punished through criminal sanctions. And for those young people between the ages of 12 and 17, as I mentioned, they are processed through the criminal justice system under the auspices of the Youth Criminal Justice Act, which is fundamentally different from the criminal code in a number of ways, most with respect to the sentencing and punishment, or how young offenders are dealt with generally through the system. And if the emphasis of the Canadian criminal justice system is on justice and rehabilitation and reintegration, that's doubled with respect to young offenders. In this country, there's particularly strong emphasis on ensuring that the majority of young offenders are not dealt with through harsh punitive sanctions, in particular incarceration, but are dealt with through alternative sanctions. And again, this is a reflection of the fact that the vast majority of young offenders in this country are not chronic violent offenders. They're generally first-time offenders who don't need to be dealt with in a harsh way. And that's the general overriding philosophy of the Youth Criminal Justice Act. So we shall begin this lecture with a broad overview of recent statistics on youth crime and young offending in this country. Basically, the youth crime rate increased during the 1980s in the very early part of the 1990s. However, like the overall crime rate in general in Canada, we have seen a decline in the youth crime rate in this country. So the decline began around 1991, and you saw a general decrease in the youth crime rate between 91 and 99. There was a bit of an uptick in 2001 and 2002, and then there has been pretty much a decline since then. And the decline in the youth crime rate has been reflected in both the property crime rate, so property crimes, as well as the youth violent crime rate. So one of the questions we have to ask ourselves when we look at crime rate statistics, that is, crime that has been recorded by police, is whether or not the number of crimes and the rate of crime by youth has decreased, or whether the police have simply charged fewer youth with crimes. And this is an issue that permeates all discussion of crime rate statistics. So when you're looking at crime rate statistics, it's not always an accurate depiction of the actual prevalence of criminal offending, because as we know, there's a number of criminal offenses, a number of occurrences of criminal offenses that go unreported and unobserved by police. Also, the fact is that since the introduction of the Youth Criminal Justice Act in 1995, police have actually charged fewer youth because that's a policy of the Criminal Justice Act is that fewer youth should be charged with offenses. So whether we're looking at the youth crime rate or the overall crime rate in a country, it's not always the most accurate depiction. It depends on a number of factors, and that includes the policy of police with respect to whether or not youth are going to be charged if they're actually caught committing a crime. But generally speaking, the youth crime rate, like the overall crime rate, has been dropping in Canada and the United States for that matter. And that has a lot to do as well with the fact that we have fewer young people in society. So society's actually gotten older. The more older the average age of a society is, the less crime you're going to have, because in general, older people don't commit crimes. And so when you have a reduction in the number of people between the ages of, say, 13 and 25, which tends to be the crime-prone years, then you're going to have a reduction in crime. So the less young people there are, in particular the less young males there are, generally speaking, the less crime there is. So based on the demographics of Canada and the United States for that matter, the average age of society has been increasing. There are fewer young males in their crime-prone years, which tend to translate into a lower youth crime rate. We'll turn our attention now to some statistics with respect to youth court. And the graph on this page basically provides a timeline of the statistics with respect to youth court cases between 2000 and 2011. And what's most graphic in this graph is the precipitous drop in youth court cases that began in 2003. Why was this? Well, on April 1st, 2003, that was the date that the Youth Criminal Justice Act came into effect. And the whole point of the Youth Criminal Justice Act was to divert youth away from the court into alternative justice systems. In particular, it was called restorative justice, and we'll talk a bit about the philosophy of the Youth Criminal Justice Act in a little bit in this particular lecture. But as far as statistics are concerned for the previous fiscal year, and this is taken from a report by Statistics Canada called Youth Court Statistics in Canada 2010-2011. In the fiscal year 2010-2011, the number of cases completed in Canada's youth courts declined for a second year in a row, down 7% from the previous year. So in 2010-2011, there's approximately 53,000 cases completed in youth court involving over 178,000 charges. Now, the decline in youth court cases occurred in every province, with the exception of Manitoba. Nova Scotia and Prince Edward Island actually reported the largest declines in youth court cases, down 15% and 13% respectively. The majority of cases, 73% to be exact, completed in youth courts involved non-violent offenses. So the most common cases completed in youth courts in 2010 and 2011 were for theft and break and enter. For most offense types, the number of cases completed in youth courts remained stable or decreased in 2010 and 2011. However, there were some individual offenses which saw an increase in the number of cases from the previous years, namely criminal harassment, which was up 13%, breach of probation, which was up 7%, and failure to appear, which was up 3%. Cases completed in youth courts were more likely to involve older youth, so those aged 16 and 17, and they were about 60%. So youth that were aged 16 to 17 were about 60% of all cases in youth court. Those aged 12 to 15, the lower end of the scale, represented about 40% of the cases. Youth court cases were also more likely to involve males than females, so 70% of all youth who appeared in youth court were male compared to 23% female. Over one half of all youth court cases, so 57% approximately, resulted in a finding of guilt. in 2010-2011, and the proportion of guilty decisions varied by offense generally. So cases for youth being unlawfully at large resulted in an outcome of guilt most often. So 90% of cases involving youth who were unlawfully at large involved a guilty verdict. Probation continues to be the most frequently ordered sentence for youth in 2010-2011, accounting for over half of all sentences imposed in guilty youth court cases. So 58% of all sentences where the youth was found guilty was resulted in probation. So the median length of probation sentences ordered in youth court was about 365 days or a year. During the same fiscal year, 16% of all youth found guilty in a court were sentenced to custody. So only 16% were sentenced to custody. And so this is a particularly significant statistic because, again, as we'll emphasize later in this lecture, the whole point of the Youth Criminal Justice Act is to divert young offenders, away from custody, in particular incarceration. Now that we've talked a bit about statistics with respect to youth crime and young offending, I want to turn our attention now to a categorization of young offenders. In other words, different categories of young offenders within society. And this is basically a categorization that I created. And the vast majority, if not all, of young offenders, or those at risk of offending during their teenage years, can be fitted into one of these three categories. The first category includes youth who are engaged in minor antisocial or illegal activities and also are at risk of more serious criminal activities. So in other words, they exhibit risk factors or early warning signs of later, more serious criminal activity. The second category includes youth who may be committing illegal acts that must be dealt with either through the criminal justice system or illegal sanctions. But most of these youth are not committing serious crimes, and most do not continue a life of criminal activity into their adulthood, so they don't show signs or risk factors of future chronic criminal offending. And this is the vast majority of youth. This is the vast majority of young offenders. Those who commit illegal acts that have to be dealt with through the youth court system or through alternative sanctions. But the majority of these don't show any signs of being chronic offenders. They're not chronic young offenders. They're just, again, being teenagers and often doing stupid things or taking unnecessary risks. The third category consists of a very small number of youth who engage in serious, damaging, and persistent criminal activity and are also likely to continue these criminal activities into the adult years. In other words, this is the group of chronic offenders. This is the small group of chronic young offenders who make up a disproportionate amount of crime, including violent crime. And so when you look at these categories, what becomes apparent is that you have a very small group of chronic offenders, and then you have a much larger group of youth who commit illegal acts but are not chronic offenders, and they're not at risk of becoming chronic offenders. And that is the basis of the Youth Criminal Justice Act. So that's one of the reasons why we look at this categorization, is that we know that the vast majority of young offenders are not chronic offenders and they're not at risk of continuing any type of chronic criminal activity into their adult years. So by virtue of that, we treat chronic young offenders different than we would treat those in the first two categories. The chronic young offenders will continue to be dealt with through the court system and through sanctions, custodial sanctions, including punishment, incarceration. Those in the second category, who make up the majority of young offenders, as well as those in the first category, are dealt with through alternative measures. They're diverted away from the criminal justice system. And that's the basis of the Youth Criminal Justice Act is that the vast majority of young offenders are dealt with through diversion away from the criminal justice system because they're not at risk of chronic offender, nor have they committed any type of serious crime. While a very small percentage of young offenders, those who are considered chronic offenders, those who've committed violent, serious offenses, are dealt with through the court system and may face incarceration, unlike those in the other two categories. We'll now turn our attention to some of the fundamentally different ways to respond to youth crime and young offenders. And again, this is a categorization that I created, and it generally aligns with the categorization of young offenders we talked about in the previous slide. So the basic four categories of dealing with youth crime or young offenders include prevention, treatment, enforcement and incarceration, as well as diversion and alternatives to the criminal justice system. The first approach to youth crime and young offenders is what we can call prevention. And what prevention basically focuses on is addressing and ameliorating the root causes of criminal behavior. So preventing the causes of criminal behavior from emerging in the first place. And there's a number of principles of preventing delinquent or criminal behavior, and we'll talk about this in much more depth when we talk about alternatives to the criminal justice system in the next module. But suffice to say, for this lecture, some of the basic principles of preventing delinquent and criminal behavior include, first of all, targeting groups or individuals which are most at risk. And this often includes young boys living in poverty, living in socially disadvantaged neighborhoods, boys that show early signs of aggressive behavior, a lack of empathy, and maybe even involved in some antisocial activities during childhood. So we focus on those children, and we are talking about children here. The best way to prevent criminal behavior is by focusing on children who show high risk signs, so signs of antisocial behavior. And we're not only working with the kids, we're working with the parents and the family and working with the schools, because it's their social environment that often helps to influence the root cause of criminal behavior. We're trying to address the root cause of the problem, and we know from research that antisocial behavior, that early signs of aggression, problems in school, interpersonal relationship problems, problems making friends. So there's a number of root causes of criminal behavior, but we won't get into detail what they are here. But again, suffice to say, one of the guiding principles of prevention is to address the root causes of problems that may lead to criminal offending, and in particular chronic criminal offending. So early prevention intervention takes place within the early years of a child's life. A guiding principle is that they're community-based, so that preventative activities and interventions take place in the community, including the home, in the playground, in recreational and cultural activities, in the school. So it doesn't take place in a hospital, or certainly not in a correctional institute, but within the neighborhood and the home and the family-based environment. Prevention also emphasizes the need to focus on the unique needs and situations of at-risk individuals, in particular at-risk kids. And so each child that is at risk of future criminal behavior has a very unique set of problems in his or her life. And so these unique set of problems need to be understood, and they need to be addressed. In other words, any preventative interventions need to be highly individualized to each at-risk child. The more risk factors addressed, the better. So kids that are most at risk are kids that have a high number of risk factors. And so the more we can address all those risk factors, the more chance we have at basically eliminating those risk factors. When we try to address multiple risk factors, we use multiple solutions, and these multiple solutions focus on the child. Again, they focus on the family, the parents, on the school. And finally, when we're talking about multiple solutions, we're talking about different kinds of interventions. And certainly, interventions that have been shown to work include mentoring, so having a child mentored by a positive role model, social and life skills development, and this includes anger management skills, perhaps fostering more empathy. When kids and youth get older, you're talking about job training. Obviously, the schools and education is absolutely essential. So kids that are at risk are ones that often do poorly in school. They may have a learning disability. They're at risk of dropping out of school. So focusing on educational interventions, keeping kids in school and ensuring they do well in school is a very important preventative approach. Addressing psychological disorders, mental health disorders, learning disabilities. So once again, prevention is generally used for children and young adolescents who display signs of early antisocial behavior. So signs, risk factors that indicate they may get involved in criminal and delinquent activities when they get older. Again, they're not predestined to become criminal. It's simply that they are experiencing a number of factors that put them at risk. And if we can address those risk factors early in life, then we can prevent criminal behavior from occurring in the first place. So again, prevention is primarily addressed at children, in particular young boys, who show signs or factors that put them at risk of future chronic criminal behaviors. Now, the next category of responses to youth crime and young offenders is what we call treatment. Now, if prevention is focusing on children that are at risk of becoming involved in criminal activity, treatment is dealing with youth and young offenders who are already involved in criminal activity. And so what we're talking about is treating the symptoms and the causes of this antisocial and criminal behavior. And so treatment is a very effective approach and is shown to be effective. Certain treatments are shown to be effective, but they're also very expensive, and they often require the use of a therapist, psychologist, and it's often far more difficult to treat the problem as opposed to prevent the problem. Now, with that said, when we're talking about treatment, we're talking about reintegrating young offenders back into the community, back into society, trying to encourage pro-social behavior, trying to encourage law-abiding behavior. So community is once again the focal point for treatment. It's considered the optimal place for treatment of young offenders, certainly in contrast to correctional institutions. And some of the treatment techniques that have been shown to work include individual or group counseling and therapy. Obviously, substance abuse treatment is quite important because we know there is a causal relationship between substance abuse and criminal offending. Social and life skills development, again, similar to what we talked about with the preventative category. But again, we are emphasizing dealing with the absence of certain social skills and life skills that may lead to criminal offending, such as a lack of empathy, anger management problems, etc., etc. So again, treatment here is concerned with helping youth deal with their anger or become more empathetic towards others. Education, again, is not only a preventative mechanism, it's a treatment mechanism. So getting youth back into schools, helping them with their learning disability, providing tutors, and most important, helping them complete school, because we know that dropping out of school has a strong causal relationship with delinquency and criminal offending. So getting youth back into school, getting them back in the educational system, getting them to complete school is considered an important treatment approach. And finally, employment is also can be considered a treatment approach. Getting them into the workforce, getting them a stable job, a stable income, and this includes everything from job training to job placement. Getting youth into the labor force is seen as an important way not only to prevent criminal behavior, but also to treat some of the causes of criminal behavior, in particular a lack of employment. Now, one particular type of treatment that is shown to be effective with young offenders is what's called cognitive behavioral therapy. Cognitive behavioral therapy focuses on, first of all, the cognitive and behavioral deficits of offenders, while also providing them with the pro-social alternatives and expressions. So the theory behind cognitive behavioral therapy is that criminal behavior is caused by a pattern of thinking. And so young offenders are asked to examine and become familiar with their own offense cycle and the root causes of their criminal offending so that they can actually address it, they can interrupt it, and then prevent themselves from becoming involved in further criminal offending, from basically becoming involved in recidivism. So, cognitive behavioral therapy interventions include a number of approaches, but they basically revolve around what's called cognitive self-control. So that is teaching and training young people and adults, for that matter, to control the causes of criminal or antisocial behavior. So once again, focusing on anger management, social perspective taking, which basically is getting them to understand their place in society and how they deal with others and being able to understand the perspectives of others. Moral reasoning, which involves trying to get them to understand the consequences of their actions and the immoral aspects of their actions. And of course, cognitive behavioral treatment or therapy also consists of substance abuse treatment and social problem solving. So teaching youth to be able to solve problems or solve dilemmas in their life without resorting to crime or violence. So cognitive behavioral therapy basically is about trying to instruct and guide offenders, including young offenders and adult offenders, in thinking in ways that help them avoid situations that would entail antisocial behavior. So some examples of cognitive behavioral treatment for young offenders include what's called multisystemic therapy, functional family therapy, life skills training, and even Job Corps, which is primarily focused on training, job training, and job placement. But I would encourage you to Google any of these terms on the internet and become more familiar with one or more of them. And as far as the case study exercise for this module is concerned, is to look more in depth of these different approaches to dealing with young offenders and treating the causes that can lead to young offending and to criminal behavior in general. Another obvious response to young offenders and youth crime is punitive sanctions, punishment, incarceration specifically. So when we talk about punitive sanctions, we are primarily referring to incarceration, but we're also talking about other punitive sanctions that have been used to deal with young offenders, and this includes boot camps, and also includes what's called shock incarceration, and you may be more familiar with the Scared Straight program, where young offenders are brought into prisons or other custodial institutions, and the idea is that they're shocked into going straight. Incarceration, shock incarceration, and boot camps have generally proven to be ineffective in responding to youth crime. In particular, punitive sanctions are generally ineffective in their effects on reoffending rates. So they don't generally have any impact on recidivism. And if they do have an impact, the impact is sometimes to increase the risk of recidivism. So incarceration, for example, is probably one of the worst things that you can do for a young offender, especially a young offender who's not at risk of chronic offending, because you're putting them in an environment, a very negative environment, and an environment where they can actually learn how to be more effective offenders. They network with other offenders. And again, it's not an environment that's conducive to addressing the causes of criminal behavior from either a preventative or a treatment perspective. So the research indicates that at best, punitive sanctions produce small decreases in reoffending rates, and at worst actually produces an increased rate of offending. In Canada, incarceration or other punitive sanctions are the last resort, and this is especially true under the Youth Criminal Justice Act. So they're really, incarceration is reserved for chronic, serious, violent young offenders. And the majority of young offenders, especially those who are involved in offending for the first time or don't pose a risk for future chronic offending, are dealt with through alternative sanctions, which we'll talk about in the next few slides, and is the focus of the Youth Criminal Justice Act. So, reintegrative parole is very much emphasized for incarcerated youth. So in Canada, even when youth are incarcerated, parole is considered an important aspect of their custodial sanctions. And again, this flows from the whole idea that young offenders should be reintegrated back in the community where they can receive the treatment, where they can be around friends and family, and where there's the best hope that their pro-social values and a law-abiding nature can take effect. Now, the final category of responses to young offenders and youth crime is what we call diversion and alternatives. In other words, diverting youth away from the criminal justice system, diverting them away from punitive sanctions, and in particular incarceration, towards alternative justice systems that have the best hope of dealing with these young offenders and addressing the overall goals of youth criminal justice, which is avoiding recidivism, dealing with young offender based on their own characteristics, and trying to ensure that the community safety and public safety is protected as well. Now, when we talk about this category of diversion, what we're really talking about in Canada is the Youth Criminal Justice Act, because the primary philosophical approach of the Youth Criminal Justice Act is to make a delineation between youth who have been involved in delinquency or criminal acts that do not represent chronic offenders, who are not at risk of becoming chronic offenders, continuing criminality into their adult years, to distinguish them from the small group of chronic violent young offenders who commit a disproportionate amount of crimes in society and should be subject to custodial sanctions and punitive sanctions. So with respect to the vast majority of young offenders, they're not at risk of chronic offending, they're not involved in serious criminal offending, and so they shouldn't be dealt with through the criminal justice system, and in particular they shouldn't be dealt with through the correctional system. Instead, they are diverted to alternative justice systems. So on October the 1st, 2003, the Youth Criminal Justice Act came into effect and replaced the Young Offenders Act, which was a more punitive piece of legislation and generally didn't make the delineation between chronic offenders, the small group of chronic offenders, and the larger group of non-chronic young offenders. So some of the basic objectives and principles of the Youth Criminal Justice Act include the following. First is a clear and coherent set of principles to improve decision making in the youth justice system, and this clear and coherent principles are very much about this delineation between chronic offenders and the other group of non-chronic young offenders. Distinguish between serious violent offenses and less serious offenses, diverting less serious cases from the criminal justice system to alternative justice systems, to reduce the high rate of youth incarceration, to help address the root causes of criminality among youth, and the effective reintegration of young people. So as you can see, many of the principles of the Youth Criminal Justice Act are not only reflective of the approach to crime control or the criminal justice system in Canada and generally, but it very much is reflective of what research tells us about young offending in Canada. And that is that the majority of young offenders are not chronic offenders, they're not involved in serious criminal offending, so they should be diverted away from the criminal justice system. That incarceration is generally a negative thing for youth and young offenders in particular, so we should avoid incarceration. And we should also try to address the root causes of criminality and effectively reintegrate youth back into society, because this is the best way to deal with crime and the causes of criminal behavior in general. So as mentioned, a particular emphasis of the Youth Criminal Justice Act is on diversion, and diversion to what the legislation calls extrajudicial measures. So in other words, diverting young offenders away from the criminal justice system and away from the court system. So according to Part 1 of the Youth Criminal Justice Act, the objective of the legislation is to increase the use of alternative measures for less serious offenses committed by young offenders. And so the legislation strongly encourages police and prosecutors to divert young offenders to community-based alternative justice processes. And so police and prosecutors are not simply encouraged, there is a very strong emphasis on ensuring that young offenders involved in less serious offenses are not processed through the criminal justice system. So in other words, if a young offender has been caught with a bag of marijuana, for example, the legislation strongly encourages a police officer to divert the young offender away from the criminal justice system. In other words, instead of laying a criminal charge, to divert that young offender towards community-based justice systems that are in place in the community. So when we talk about alternative justice systems as far as the Youth Criminal Justice Act is concerned, as far as young offenders in Canada are concerned, we're talking about what's called restorative justice. And restorative justice, as your textbook outlines, and as we'll talk about in more detail in the next module, is basically the opposite of the adversarial criminal justice court-based system. It's basically, instead of having the victim and the offender, or the offender and the state combat over what the truth is and what justice is, what restorative justice does is basically bring the victim and the offender together to talk about the crime, to talk about the aftermath of the crime, and to come to some type of conciliatory agreement on the problem itself, on the crime itself, and how it should be dealt with. So we'll talk about this in more detail. But restorative justice has been shown to be effective with young offenders, and it's particularly effective with offenders who are not chronic, serious, violent offenders. So what the Youth Criminal Justice Act emphasizes is a diversion away from the criminal justice system to more restorative approaches to justice, in this case, to offending. But at the same time, restorative justice is not necessarily a soft approach to young offenders. The Youth Criminal Justice Act and restorative justice emphasizes meaningful consequences that include requiring the young person to repair the harm done to the victim. In addition, in order to qualify for this diversion, in other words, in order for a young offender or the youth involved in a particular process to be diverted to a restorative justice process, the youth has to admit guilt. That's the first step. They can't be diverted unless they admit guilt, unless they express some form of remorse, unless they apologize to the victim, and unless they take part in some form of reparations. So again, restorative justice is not necessarily a soft approach to crime. It's what I would say a smarter approach to crime, and one that shows to work, and one that will not have the same kind of negative repercussions on the youth as punitive sanctions or incarceration is concerned. Now, the other aspect of restorative justice is that it provides the victim and the community the opportunity to play a role in the process. And as we know from the adversarial criminal trial process, the victims and communities that are impacted by crime generally have very little say. So instead of the process being between the offender and the state, here it's between the offender and the victim and the community that's impacted. And instead of being adversarial, the whole approach is to be more conciliatory. So the point here is that in Part 1 of the Youth Criminal Justice Act, emphasis is on what's called extrajudicial measures, and so that's diversion away from the court, away from the criminal justice system. And if the youth successfully completes the restorative justice process, they will not have a criminal record. And that's probably one of the most important things to remember from this process, is that they will not have a criminal record. And again, that's a reflection of the belief that the last thing we want to impose on youth who have been involved in some minor forms of crime to have a criminal record. So again, the process is seen to be one that's much more beneficial to the offender, for the victim, for the community, and for society as a whole. As far as sentencing is concerned, the Youth Criminal Justice Act very much makes that delineation between young offenders who are sentenced to the restorative justice process and those who are sentenced to custodial sanctions, punitive sanctions. As mentioned, again, the young offenders involved in less serious crimes who are not at risk of chronic offending are diverted towards the restorative justice process, while more serious offenders are processed through the traditional court system. So the purpose of sentencing under the Youth Criminal Justice Act is still to hold young people accountable through different sanctions, through just sanctions that ensure meaningful consequences and promotes their rehabilitation and reintegration into society. Now the question is, what constitutes just sanctions? Again, for young offenders who are not at risk of serious chronic offending or who have not been involved in serious chronic offending, a just sanction is one that entails the restorative justice process. So apologizing, expressing guilt, expressing remorse, and then working with the victim and the community to basically repair the harm done by the crime. A just sanction for a more chronic young violent offender may in fact be incarceration and may be other punitive sanctions. So the point here is that the penalty or the punishment must fit the crime. And incarceration is not a punishment that fits all crimes, and nor is restorative justice, because there are violent chronic young offenders out there who do need to be incarcerated, and it's in their best interest and society's best interest that they are in fact incarcerated. But what the Youth Criminal Justice Act specifies is that incarceration, again, is the last resort. And it develops a specific set of criteria that must be met by a judge if a young person is to be incarcerated. And so basically the court must have considered and rejected all other reasonable alternatives to custody before a young offender is sentenced to incarceration. And so the Youth Criminal Justice Act provides youth court judges with a number of alternative sentences, including reprimand, intensive support and supervision orders, deferred custody and supervision, intensive rehabilitative custody and supervision, alternative justice systems like restorative justice. And so judges are given a wide range of latitude to determine the sentence, and most importantly to divert young offenders away from incarceration if they in fact have made it to the youth court system. But again, the important thing to recognize is that the emphasis on the youth criminal justice system is to keep youth out of the court system in general. But if they do enter the court system, if they are not diverted by a police officer to a community-based process, then at least the sanctions available to a judge in the youth court are such that they can look at alternatives to incarceration, and there's a wide range of alternatives to incarceration. Now we'll deal with one more issue that was changed with the introduction of the Youth Criminal Justice Act, and that is how young offenders are dealt with in adult courts, or the adult sentencing of young offenders. Under the Youth Criminal Justice Act, youth are no longer sent to an adult court. That was the case under the previous legislation, the Young Offenders Act. So youth are still tried in a youth court. They're not sent to an adult court if it's a serious violent offense, for example. However, a youth court can hand down an adult sentence. So these are sentences that are described and codified in the Criminal Code of Canada. So the one difference between the Youth Criminal Justice Act and the Criminal Code of Canada is that the Youth Criminal Justice Act also describes punishment and sentences for young offenders, and as we described in earlier slides, these are substantially different than the Criminal Code. So the minimum age that a court can apply an adult sentence is 14, although some provinces have the legal authority to set the age at 15 or 16, but for most provinces it's at 14. In other words, 14 and up, between the ages of 14 and 17, are the ages where a youth court can sentence a young offender to an adult penalty, an adult sentence, based on what's in the Criminal Code. However, again, the Youth Criminal Justice Act very much emphasizes the avoidance of adult sentences for young offender. The process is that the youth court first must determine whether the young person is guilty of the offense, and obviously then they pose an adult sentence. But before an adult sentence can be considered, the judge has to take into consideration certain criteria. First of all, one of the criteria is that in order for a youth to receive an adult sentence, there must be a pattern of repeated serious violent offenses. And this is probably one of the most important aspects or important criteria that a judge must follow. The court cannot impose an adult sentence if it's not sought by the Crown. So in order for a court to impose an adult sentence, it first has to be sought by a Crown prosecutor. And lastly, the court must consider a youth sentence before handing down an adult sentence. In other words, it has to consider the viability of a sentence as dictated by the Youth Criminal Justice Act before it considers a sentence in the Criminal Code. So once again, the Youth Criminal Justice Act really implores judges, sentencing judges, to look at alternatives to punitive sanctions, in this case adult sentences, and always encourages judges to look at alternatives, in particular sentences under the Youth Criminal Justice Act, before it turns to the Criminal Code for sentencing of young offenders. As with the adult correctional system, one of the most important emphases of the Youth Criminal Justice Act is that youth are released from custodial sanctions as quickly as possible, as long as their risk of reoffending is minimized, and to get them back into the community where they can be supervised and reintegrated back into society. So as far as the Youth Criminal Justice Act is concerned, every period of custody by a young offender is to be followed by a period of supervision in the community as part of the sentence. So every sentence, every custodial sentence handed down to a young offender includes a period of supervision in the community, basically a period of parole. So the legislation contains a number of mandatory conditions that apply to all young people while they are under supervision in the community. And many of these conditions are similar to what we talked about in the lecture on parole. And of course, judges can apply additional communities based on the circumstance of each case. If a young person breaches any of these conditions, then his or her case will be reviewed, and there is the potential of the youth to be returned to custody, just like in the adult system. So as you can see with the Youth Criminal Justice Act, it's very much a reflection of the Canadian criminal justice system in general, and that is to ensure that only the most chronic, violent, recidivist offender is incarcerated, and even those who are incarcerated should be given the opportunity to be released early from their custodial sentence and returned back into the community where they can be reintegrated and treated, and every effort made to ensure that they don't reoffend and they become law-abiding citizens of society. And so once again, the Youth Criminal Justice Act very much emphasizes this principle of reintegration, but reintegration that is conducted in a supervised manner. As with the adult system, youth who are incarcerated will be subject to what's called a reintegration plan. So a reintegration plan will be drafted for the young person, and basically when a youth goes into custody or incarcerated, the legislation requires a youth worker to plan for the reintegration of the young offender back into society. And this youth worker will often stay with the young offender as a supervisor and as a support system when the young person is released back into the community. So like the adult reintegration plan, for youth, the plan basically sets out the most effective program for the young person to maximize his or her chances for successful reintegration. And the youth worker will supervise and provide support and assistance to the young person while serving the supervision portion of their sentence, in other words, while they're back in the community. And again, you can see that the reintegration process for young people is very similar to those for adults.